Call to order. We're ready to start. Could we have the roll call, please, Weston?
Yes, Mayor. Mayor Sticks.
Here.
Mayor Pro Tem Francina via Zoom.
Yes, I'm here.
All right. Councilmember Roll.
Here.
Councilmember Lang.
Yes, here.
Councilmember Whitman.
Yes.
Thank you, Weston. Welcome, everyone, to the special meeting, closed session of the Monday, November 13th meeting of the Ojai City Council. And I do have a statement to read about Mayor Pro Tem coming virtually. So the Brown Act authorizes members of the City Council to participate in meetings remotely under certain conditions. Assembly Bill 2449, which was signed into law by Governor Newsom on September 13th, 2022, and is effective January 1st, 2023, permits council members to participate in city council meetings remotely when they can demonstrate just cause or emergency circumstances and when a quorum of the city council is physically present in the city. Mayor Pro Tem Francina is participating in tonight's meeting remotely under AB 2449. Mayor Pro Tem Francina is participating on the emergency circumstances exception given a illness. Not feeling well. We're sorry you're not feeling well, Mayor Pro Tem. Mayor Pro Tem Francina will be participating in tonight's meeting using visual technology. Per AB 2449, a council member participating remotely due to emergency circumstances requires council consent. I'll ask if there's any opposition to this request. Nope. Seeing none, we will proceed. Council members participating remotely under AB 2449 are required to disclose at the start of the meeting whether any other individuals 18 years of age or older are present in the room at the remote location with the council member and the council member's relationship with the individual. Mayor Pro Tem Francina, would you please confirm that you are the only person 18 years or older in the room you are teleconferencing from, or else disclose those persons over 18 present with you?
Yes, I confirm that. Just me and my two dogs.
Okay. Thank you. As required by AB 2449, all votes taken tonight will be done by roll call. Thank you. Okay, so we will then move on to the pledge. Weston, will you say the pledge for us, please?
Yes, Mayor. Everybody please stand. Place your right hand over your heart. Ready, begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Weston. And now we have a statement from our city attorney, Mr. Matt Summers. Thank you, Matt.
Thank you, Madam Mayor. The City Council, I would speak to the proposed closed session agenda. We have listed 5 items. The first 3 are anticipated litigation related to facts and circumstances that bear a significant exposure to litigation against the city regarding transactional occurrence that may result in litigation, namely city's consideration of pending housing developments proposed by Cabrillo Economic Development Corporation for 318 to 320 Bryan Street, item 1. Consideration of pending housing developments proposed by Ojai Bungalows, LP, Greenhawk, LLC, the Becker Group, Inc., for 312 West Aliso, 412 Mallory Way, 107 North Ventura Street, 304 South Montgomery Street, and 510 East Ojai Avenue, item 2. Item 3, potential housing developments proposed by Ojai Kuyama Church, LLP, Ojai Maricopa Church 1 LLP, and Ojai Maricopa Church 2 LLP for 1400 and 1450 Maricopa Highway. Those 3 items are lawful closed session items as the council can consider a transactional occurrence that may result in litigation against the city. Here, the requirement of the Brown Act is that the facts and circumstances of that transactional occurrence be disclosed on the agenda and publicly. The public disclosure is met by this statement. The agenda states the facts and circumstances, the consideration of several pending housing developments for those sites as listed. The next item, item 4, is anticipated litigation regarding existing litigation. The case name is simply Ojai v. City of Ojai, Ventura County Superior Court case number as stated on the agenda. Here we have existing litigation that is still pending and thus can be discussed by the council. Last, we have public employee appointment and public employment regarding 2 positions, the interim city manager and the city manager, and that too is lawful. We are not expecting any reportable action on these items, but rather staff to provide an update to the council on, for items 1, 2, and 3, the pending development projects, the litigation risks, and the options. No decisions can or will be made that are final regarding the projects. All of these development projects have final decisions that have to be made in public on an agenda at a public hearing with notice. Same on the litigation. We're not expecting final reportable action, nor on the recruitment there too. It's going to be direction to staff and council. And with that, staff recommends approval of the agenda as proposed. And both myself and Sunny Sultani, our outside housing counsel, are available for questions or comments.
Great, thank you, Matt. All right, is there a motion to approve the agenda?
I do have a couple of questions
Okay.
around transactional occurrences. So the way this reads, anything. Excuse me, my
Microphone, please.
Anything, a transactional occurrence, it seems to me, needs to be more specific than just considering pending litigation or pending housing development, which might equal litigation. That seems to me to be immensely broad and would allow us to basically go into closed session over almost anything. And is city consideration of a pending housing development a transactional occurrence? That is, how is the transaction in your mind happening? What is the transactional occurrence? Because the law itself, while it says it's not limited to, it tends to be much more catastrophic, like accident, disaster, incident. And then it says, or a transactional occurrence that might result in litigation. So the transactional occurrence that might result in litigation that we are going into closed session on, but yet we are making no decisions. So I'm not sure how it could result in litigation if we are making no decisions or we're not reporting out. I just want to be very clear because all of us here have agreed to abide by the Brown Act, to the letter of the Brown Act. So I have a question about that. And if you would answer that would be great. Thank you.
Sure. So the transactional occurrence here is the city's disapproval or approval with conditions or any other lawful action that might be taken regarding each of the 3 development projects. It is a transaction in that the developer, the applicants, have applied to the city for 1 or more permits for the addresses as stated, and the city has an obligation under state law in the end to give them a decision. That's a transaction. The transactional occurrence is sufficiently specifically stated because the Brown Act doesn't require detail. It requires enough information to provide a reasonable person to understand what is that transactional occurrence. We've provided that with the name of the applicant and the name of the address. If someone wants more details, the applications are available for review at City Hall upon request. The other point I would note there is the fact that the council will not be making a final decision on the applications tonight does not mean that there's not a risk of litigation from whatever that final decision may be in the future. So it's lawful for the council to discuss the options, what those decisions could be, the litigation risks thereof, but not to make the decisions tonight. It's a discussion of the options and litigation risks. The decisions come in the future. The lawsuits, if they are filed, will come in the future, but it's still lawful to discuss what's on the table and the litigation risks that may stem from that.
And I can elaborate a little bit about that because I understand that this council is very, very, very transparent and has made it a policy to conduct its meetings publicly. But the act itself provides that facts and circumstances that might result in litigation, but which the local agency believes are not known yet to the plaintiff or a potential plaintiff, need not be disclosed. And there's good public policy behind that. The legislature provided that language in the act because they want to allow for effective and confidential legal counsel with the policymakers about that. So just because you're not making a final decision, if there are facts known, and it's the judgment call of the city attorney and the council and staff, and either one of them can have that judgment call that there is a fact or circumstances known that might not be known to the other side yet, that needs to be discussed freely to provide effective legal counsel for the taxpayers. And that needs to be discussed in closed session. And the act, if you look at the language, it says it. It says, whenever there are facts and circumstances that are not yet known to a potential plaintiff or plaintiffs, which facts and circumstances need not be disclosed. And that's Government Code Section 54956.9E1. So the Act itself provides for that. And so I hope that addresses any concerns you have. And I actually, in the memo that I've done for the council, because I knew this would be an issue, I've discussed this in detail, and I'm happy to elaborate on it in closed session as well.
Okay.
And if I could make one
yeah,
final point
please.
before you.
Yeah.
The last point is going to closed session is lawful. Firmly believe it is lawful. It's a policy choice, though. If council wants to have a discussion in open session, that's fine. We agendize it for a future meeting if desired. But it is lawful to go into closed session on all 5 items as listed, and staff would recommend we do so to allow that free and open discussion for the council.
Okay. Yes. So just for my edification, because I'm learning all the time, when you cited E1, would that have had to have been part of the code that's referenced on the agenda? Because E1 looks to me, and I don't know what it is, looks like D2 and E2, which I know are very specific references to codes. And we've also been under great scrutiny for misagendizing items. So, and while I don't know if E1 is actually the same as E2, only different. So my question to you, do you understand the question?
So if I could jump in briefly.
Yeah, please.
We've cited only E2 because the council gave us prior direction to not use E1 because it doesn't disclose to those potential plaintiffs what the facts and circumstances are. So Mrs. Sultani is speaking very broadly on the allowances, even broader than we've used. We've cabined it further to require only use of the E2 allowances for which requires disclosure of the facts and circumstances as disclosed.
That's what I was going to say. The point I was trying to make is that the act actually goes beyond this, and you could have, your closed session listing actually references the titles of the properties, but arguably you could have just said E1 and leave it at that and not even discuss what you're talking about. And the point I was trying to make, and you know, I started my legal career as a litigator, and I was a litigator for 12 years before I transitioned to become a city attorney. And I really believe sometimes when there are potential litigation luring on a matter, it is so effective for the policymakers to be able to freely speak to their staff and their city attorney to guide the dialogue. And it provides us with an opportunity to give you better counsel, because sometimes as litigators, when we have our lawyer hat on and we believe if there's something we say that the applicant may be able to use against our client in a court of law, we may hold back on that. And this legislature was specifically passed because otherwise it's unfair to local agencies. Think about it. Developers, applicants, they get to go sit around in a private room and talk about their legal strategy, and then come to public agencies, and public agencies, if they had to discuss all these strategic issues with respect to potential litigation publicly, they would lose every single litigation, because then the other side would know exactly what their legal strategy is. So that's why the legislature went out of its way to provide these narrow exceptions to allow this to occur.
Yeah, no, I understand the logic behind the Brown Act very well. I don't think there's any question about that. My question really is if we're relying upon E1, but we've noticed E2, is that problematic? That's all I'm saying.
And I think Matt's telling you that the city's relying on D2, but I was just expanding and saying even if you had relied on E1, you could have agendized this properly, that you were actually giving more information about the matters.
Okay, so just in closing, you're saying that the transactional occurrence that we're citing is the potential litigation.
No, the
Okay.
transactional occurrence is the city's consideration of the development agreements.
But
the
doesn't
development projects.
doesn't
That might result in
transaction
litigation.
doesn't transaction have to have a give and a take? Like, that's what I thought transactional meant.
It doesn't mean
Transactional is
purely contract where you have a consideration. It also includes a situation where an applicant seeks the permission of the city to do something under current law, and the city does or doesn't grant that. That's also a transaction.
okay. So we're saying that the transaction is that the city has put in some sort of request to us, and that would be their part of the transaction, and our part of the transaction is to go into closed session and discuss it.
No, the transaction is the developer has asked for approval to build a project or
Right.
build projects.
Yeah, right.
We have to grant or deny or approve with conditions or
Okay.
do something else.
Okay.
The application for the permit is the transaction.
Okay, that was my question. The
Yeah.
application for the permit is the transaction.
And then the city's decision on that transaction, the city's piece of that transaction is what may or may not result in litigation.
Okay,
It
and
might result in litigation, hence the basis for the closed session.
right, but we are not forced at this particular point to make a decision such that that transaction actually happened.
Correct. The transaction isn't complete yet, but that still doesn't allow the transactional occurrence is still existing.
Okay,
It's in process.
okay,
And that lets us have the closed session discussion of it.
okay,
The other key there is that there's no requirement under E2, it's distinct from E1, that there has been or not E1, E3, the other one. There's no requirement that there have been a threat of litigation. E3 and E4 and E5 are the threats.
right,
E2 allows for a transactional occurrence or incident or fact that the city believes may result in litigation or might result in litigation, to quote the statute, allows for a closed session even if those litigants who might sue the city haven't yet made that threat.
okay.
So that's why
yeah,
you're not seeing letters threatening litigation.
right,
There's no requirement for there to be a threat for E2. It's distinct from E3 through 5.
right. There just needs to be a significant exposure.
Correct.
Okay,
And
thank
we
you.
believe that is present. And
Okay.
just to finish the puzzle, that's present because if the city denies these projects, litigation is nearly certain based on the developer's past statements. If the city approves the projects, it may result in litigation by project opponents based on their past statements and actions.
Okay, thank you for clarifying. I just, I need to be sure. I need to be really sure around the housing that we're doing because it's going to get very contentious. And it's good for everyone, including the public, to know how this gets agendized and what it means. It's good for people to know that what a transaction is. It's an application in. And, so thank you for your time.
Happy to
I'm not
clarify.
meaning to be argumentative. What I'm meaning to be is understanding and getting a sense of it, as well as for the public to get an understanding of it. I think it's super important.
That's our job, and we thank you for
Absolutely.
asking the questions, and I'm sure a lot of members of the public are appreciating the questions.
Great, thank you. Is there a motion to approve the agenda?
I will make a motion to approve the agenda.
Okay, second?
Second.
Okay, a roll call, please, Weston?
Mayor Pro Tem Francina.
Yes.
Councilmember Lang.
Yes.
Councilmember Whitman.
Yes.
Mayor Sticks.
Yes.
Councilmember Rule.
Yes.
Motion passes.
Thank you, Weston. And are there any public comments, Weston?
No in-house and no attendees on Zoom, Mayor.
Okay, thank you. Well, are we ready to go into closed session?
With that, we can recess into closed session.
Okay, we
Everybody
adjourn.
in the conference room.